Now recognize Mr. Chenoweth for his 5 minutes for his opening statements.
Good afternoon, Chairman Bishop, Ranking Member Ivey, members and guests. My name is Mark Chenoweth, and I'm the president of the New Civil Liberties Alliance, a nonpartisan, nonprofit civil rights group founded by Professor Philip Hamburger of Columbia Law School to fight unlawful administrative power. NCLA fills the void left by legacy civil liberties groups that no longer care about government-directed censorship. NCLA's motto is, let judges judge, let legislators legislate, and don't let bureaucrats do either. We champion the people's right to be governed by representatives they pick and Congress's job to write the laws. Congress never authorized the administrative state censorship we are discussing today. My written testimony explains NCLA's public interest litigation combating social media censorship on behalf of 4 individuals in the Murphy v. Missouri Supreme Court case. But I'm here today to sound the alarm on 4 legal principles Congress must uphold to stop the rampant censorship by DHS, CISA, and multiple other federal agencies. First, the government is not the arbiter of truth. As Justice Robert Jackson observed, the very purpose of the First Amendment is to foreclose public authority from assuming a guardianship of the public mind. Every person must be his own watchman for truth because the forefathers did not trust any government to separate true from the false. During the COVID-19 pandemic, the government proved unable to uphold truth. It peddled falsehoods that natural immunity does not exist to COVID-19, that vaccine immunity is superior to natural immunity, and that vaccines would stop the transmission of the virus. The government then suppressed dissenting voices on Twitter, Facebook, and elsewhere who dared to express rational, scientifically accurate views on COVID-19 and the vaccines. Second, the First Amendment protects even false speech. Much of the suppressed COVID speech was true, but in U.S. v. Alvarez, the Supreme Court held false statements as a general rule are not beyond constitutional protection. Were the court to hold that the interest in truthful discourse alone is sufficient to sustain a ban on speech, it would give government a broad censorial power unprecedented in this court's cases or in our constitutional tradition, end quote. This means labeling disfavored speech as misinformation, disinformation, or malinformation does not strip it of First Amendment protection. Third, the government may not do indirectly what the First Amendment forbids it from doing directly. It is axiomatic, according to the Supreme Court, Norwood v. Harrison, 1973, that the government may not induce, encourage, or promote private persons to accomplish what it is constitutionally forbidden to accomplish. The bully pulpit does not include the power to harangue social media platforms to remove the lawful speech of third parties. When the government coerces or pressures a company with threats and the company responds by censoring private individuals, that is unlawful state action. But if the government writes and tests software to effectively monitor and shut down disfavored speech and then turns that over to private actors to run the software that censors the speech, that is also forbidden state action. It doesn't matter that it's indirect. The First Amendment bar is much lower. Fourth, the First Amendment term abridging supplies the test to determine when the government has violated the right to free speech. The only question for the courts is whether the government's conduct has led to the abridging, that is the diminishing of speech. The test is not coercion. It is not whether something was compelled. It's not pressure. It's not entanglement. It's abridging. The First Amendment prohibits government from abridging speech, which contrasts with the narrower term prohibiting in the Free Exercise Clause, as my written testimony citing Professor Hamburger explains. I will close with 3 examples that illustrate the scope of the problem with government-led censorship through CISA switchboarding and other practices. First, the Virality Project flagged Harvard Med School epidemiologist Martin Koldorf's tweet, which stated, quote, thinking that everyone must be vaccinated is as scientifically flawed as thinking that nobody should. COVID vaccines are important for older, high-risk people and their caretakers. Those with prior natural infection do not need it, nor children, unquote. This tweet was censored and his account flagged. Second, the Virality Project wrote a report in which another NCLA client, Bri Dron, was identified as a purveyor of misinformation for discussing the adverse, devastating effects she personally suffered from the AstraZeneca vaccine after she volunteered for a vaccine trial, even though NIH itself had diagnosed her as vaccine injured. In NCLA's Dressen v. Flaherty case, we are suing the government for shutting down Bri's support groups for vaccine injured individuals. These are private online groups where vaccine injured people can turn for emotional support. When their support groups were deleted, group members failed to get assistance they could have gotten that would have led to better treatments for them. At least one committed suicide. This is private speech we're talking about among already vaccinated people who want to converse with each other and share their stories. They will not promote vaccine hesitancy to the general public because the speech occurs in private forums. And yet the government is still suppressing that speech as we sit here. This is insanity. Third, White House pressure led the lab leak theory to be censored on social media. When Meta head of Global Affairs, Nick Clegg, asked a colleague why the story had been censored on Facebook, the colleague replied, quote, because we were under pressure from the administration and others to do more, unquote, and that, quote, we shouldn't have done it, unquote. Meta also acknowledged changing its policies regarding content discussing adverse vaccine events to avoid retaliation from this White House. In sum, these responses to dissenting COVID-19 views show the dangers of government censorship. The government's conduct violated censored Americans' First Amendment rights, as well as the rights of other Americans to listen and learn from those perspectives and to draw their own conclusions about their health, their vote, and the truth. This committee must force the executive branch to correct course before it completely obliterates the First Amendment. Thank you.
Thank you, Mr. Chenoweth.